Well, welcome back, everyone. I'm still Ahilan Arlanandam, Faculty Co-Director of the Center for Immigration Law and Policy here at UCLA School of Law, now seated. I hope you enjoyed this morning's panel as much as I did. This afternoon, we have what should be a fascinating conversation with Cecillia Wang, a truly gifted civil rights lawyer and tactician. Cecillia will speak to us about immigrants' rights litigation in the Biden era and other topics too, I think. And we are so very lucky to have our very own professor, Ingrid Eagly, guiding the conversation with Cecillia. Ingrid has been a professor of law at UCLA since 2008. Before that, she served as a trial attorney for the Federal Public Defender's Office in Los Angeles. And before that, as a Soros Criminal Justice Fellow at the Coalition for Humane Immigrants' Rights in Los Angeles, which we here in Southern California know as CHIRLA. Professor Eagly has done groundbreaking research on a number of enforcement issues that will be of keen interest to immigrants' rights litigators, including the prevalence of in absentia removal orders. That is to say, how often do immigrants show up to court for their deportation hearings, which is a very hot topic lately, the history and also current use of the federal criminal immigration laws, illegal entry and reentry, and access to counsel for people facing deportation. I'm sure many of you, like me, who work in the field will have cited this disturbing statistic. 86% of detained immigrants do not have a lawyer in their final merits hearing. That study was done by Professor Ingrid Eagly. Thank you so much for guiding this discussion today, Ingrid. The floor is now yours.
Great. Thank you so much, Ahilan, for that generous introduction. And it's now my great pleasure and honor to get to introduce Cecillia Wang. Thank you so much for joining us today for this conversation. For those of you who don't know Cecillia, she's the Deputy Legal Director at the National ACLU, where she has litigated literally some of the very most important immigrant rights cases of our generation. Her focus both as Director of the Center for Democracy and formerly as the director for the ACLU Immigrants' Rights Projects, has included a whole range of related issues, including national security, human rights, privacy, and issues at the intersection of immigration and criminal law, including state anti-immigration laws, racial profiling, and other unlawful police practices. And these are all issues and cases that we'll be talking about today with Cecillia. Her career also includes time spent at the Federal Public Defender's Office for the Southern District of New York, and as a member of the Federal Criminal Justice Act, or CJA, panel for the Northern District of California. Cecilia's impressive bio also includes graduating from Yale Law, clerking on the Supreme Court, and also on the Ninth Circuit Court of Appeals. So welcome, Cecillia. Thank you so much for joining us.
It's always great to be teamed up with you, Ingrid.
I'm really looking forward to this conversation. We've talked a little bit about your formal background and experience, but I wanted to get some more insights from you. You've been so dedicated to both criminal defense and immigrant rights ever since graduating from law school throughout your entire career. So I'm interested in knowing, what drives you to this work and why have you pursued this field?
Yeah, I mean, I'll have to indulge in some, personal sharing to answer the question. I think, like a lot of second-generation Americans, I've been drawn to the immigrants' rights movement and to civil rights work more broadly because of my own family background. My parents both immigrated to the U.S. in 1968, and it was as a result, as I learned in college, of the 1965 Immigration Act, which lifted racist quotas on Asian immigration and immigration from other parts of the world for all time and for good. And the 1965 Immigration Act, of course, was something that came out of the civil rights movement. It was part of all the legislation that Congress passed in light of the March on Selma and all the other work, the blood, sweat, and tears, lives lost in the battle against Jim Crow in the South by Black Americans, led by Black Americans and allies. So, part of it, the reason I was drawn to the movement is that personal history. I feel that I owe kind of a debt to work on civil rights issues. I owe a debt because of the sacrifices that immigrants like my parents made in order to make it possible for me to be an American and to be a US-born US citizen. And I owe a tremendous debt to civil rights freedom fighters here in the US, led by Black Americans. I think the other reason that's also related to my personal background is the flip side of that immigrant family experience, I think, is that, you know, as a kid, when you experience racism, whether it's playground taunts or street harassment and other forms of bias, you know, I struggled a lot growing up in a city in the Bay Area, Fremont, that was going through a lot of demographic change at the time I was growing up. My high school, when I attended, graduated in 1988, was, I think, around 6% Asian, and it's today about 85% Asian. And so when you're in the vanguard of that kind of demographic shift, that's when I think a lot of the friction and racial tensions, you know, come to light. And it wasn't until I got to college, I went to Cal and took a lot of ethnic studies courses and learned about the history of civil rights movement and the struggles, our ongoing struggles for equality, and making the promises of our Constitution a lived reality for everyone. Those are all things that motivated me to go into this work.
Thank you for that. You've led such a trailblazing path, and the past 4 years have been absolutely no exception. I'm exhausted just following all of the work that you've been doing and inspired at the same time. I was wondering if you could just share with us sort of some of the highlights, some sort of the silver linings that we can see from the past few years in terms of the high watermarks for how litigation can shape immigration policy.
Yeah, you know, I think you and Ahilan are both really generous in inviting me to speak, but as I don't need to tell both of you, and I think everyone in the audience here, you know, no one person, no one advocate is responsible for the progress that we've made and for the fights that we've fought valiantly and still haven't won. It really has taken an entire movement of people, not just litigators, not just lawyers, but all of us using whatever tools we have, and you know, people who aren't full-time advocates. So I want to start with that. You know, I think reflecting on the 4 years of the Trump administration, you know, I have kind of conflicting emotions about it. One is, in our lifetimes, we had not seen, and hopefully will never again see, the President of the United States and you know, the U.S. government and many state and local governments really trying to take our country backwards, not only in terms of immigration policy per se, but using immigration policy to try to advance this really retrogressive view of what America means and what American means. The president, you know, I don't need to rehash it, but starting from, you know, day 5 or so of his term in office, when he issued his 2 immigration executive orders, one on interior enforcement, one on border enforcement, on January 25th of 2017, and then his 3rd executive order on immigration, the Muslim ban, on January 27th, that Friday evening. He was very explicit, I think, in ways we had not seen, you know, in relatively recent times, in contemporary times, about wanting to, you know, enact white nationalist immigration policy. Everything from smearing Mexicans as rapists and criminals, to smearing Muslims as terrorists, to referring to predominantly African and Caribbean countries as, quote, shithole countries during a meeting with members of Congress about the temporary protected status program. All of those things were really blatant, and he used the enormous power he had as president of the United States, and before that as a candidate for the presidency, to advance that agenda. It was a tremendously traumatic time, for advocates, not even to mention for immigrants in this country and for people of color who were targeted by his policies. And I just have to give so much credit to my colleagues at the ACLU, but also partners at so many other organizations, not just ones that focus on legal work like NILC, or the National Immigration Project of the National Lawyers Guild, NIJC. So many, I don't want to list them because I'm going to not be able to name them all. But really the organizations that are focused on grassroots work, take the Muslim ban, for example, and maybe I'll stop with a reflection on that point. When the president issued the Muslim ban on the evening of Friday, January 27th, 2017, Make the Road New York and the New York Immigration Coalition were ready. They mobilized people to go protest at JFK, and other local grassroots-oriented immigrant advocacy organizations and immigrant-led organizations mobilized at other airports around the country that weekend as Saturday and Sunday unfolded. And that energy that really focused on Trump's first big move as president, which was the Muslim ban, really put immigration front and center, I think, on the progressive agenda. But I think we're going to be processing the trauma and the policy and legal damage done by the Trump administration for some time to come. I started out saying I have conflicting emotions because I do think there's a big silver lining to the Trump administration, which is that what he did as president on immigration was made possible by long-standing doctrinal tools, legal, statutory tools. And I think that the ways he abused executive power in ways that were unconstitutional, that were contrary to statute, really helped to see a much broader segment of our fellow Americans, what the dangers are. I've said before, he went around, Stephen Miller and his other policy architects, literally comb through the Immigration and Nationality Act and looked for those loaded weapons that he could use and use them for all he was worth. And the silver lining, I think, is that there's going to be an increasing awareness, I hope, on the part of government officials, members of Congress, members of the current administration, and the general public that we need to fix some of those problems. We cannot have untrammeled executive power when it comes to immigration. We need to have judicial review, and we need to have very strong checks and balances and enforceable ones.
One of the things that you touched on is just the role of so many different partner groups and community organizations and community members alongside litigation and other techniques as being important, sort of this idea of integrated advocacy that we talk a lot about in movement lawyering. And I think one really important example of that is Maricopa County, which includes, from the litigation angle, your suit against Sheriff Arpaio and the illegal practices, including racial profiling there. And I was wondering if you could talk a little bit more about that using the integrated advocacy lens and the role of litigation.
Yeah, Maricopa County, my beloved community, and home away from home for so many years. So, to continue on the kind of silver lining or the bright side of coming out of the Trump administration and before that, the wave of state anti-immigrant policy making that started in the mid-2000s and continued through Arizona's SB 1070 and through Mike Pence and Greg Abbott's efforts in Indiana and Texas against refugees, and then leading into the Trump administration. I think what's interesting to me about that is, there have been communities, immigrant-led, Latino-led communities like in Maricopa County, who've been fighting these battles for so long. And really, to not use a martial metaphor, really kind of planting seeds, preparing the ground, planting seeds. And we've seen, sowing of what's come to fruit, to flower, as a result of those efforts. And Maricopa County, I think, is, as you say, Ingrid, the one of the prime examples. You start out in, 2005, 2006, 2007, 2008. You had Joe Arpaio sitting as a sheriff, serving, I guess at that point, it was probably his third or fourth term. You had Andy Thomas, the famous anti-immigrant and xenophobic county attorney in Maricopa County. You had Russell Pierce in the Arizona State Senate, leading efforts to legislate in ways that caused race discrimination and discrimination and illegal activity by law enforcement against people of color, and particularly Latinos in Arizona. And, I think we have to remind ourselves of what things were like in Maricopa County back then. I remember when I was litigating against Proposition 100, which was Arizona state, it was actually passed by a voter referendum by about 80% of the vote was in favor of this state constitutional amendment that prohibited the release on bail of people who were deemed to be undocumented immigrants and who were charged with a huge variety of felonies under Arizona state law in violation of the Due Process Clause. And I remember that some of the people I needed to interview about that policy as it was being implemented in Maricopa County were state judges. They were the commissioners who were responsible for setting bail. And, Joe Arpaio, in cahoots with Andy Thomas, was really it was like the Wild West. Lawrence Downs of the New York Times wrote this beautiful column about the people who resisted that reign of terror, literally a reign of terror by Joe Arpaio and Andy Thomas at that time. They would go and arrest the publisher of the Phoenix New Times, the local alternative weekly, and perp walk them, in the early morning hours, and wake them up at dawn and arrest them and perp walk them. He arrested a state court judge who he had political disagreements with. He threatened state court judges. He really, by he I mean Arpaio, really ran the place like it was his fiefdom. And I remember trying to talk to these state court judges about the implementation of this law, and they would talk to me, but they'd say, please do not tell anyone that I've spoken to you, because I'm really afraid that the sheriff will retaliate against me. So you can imagine, if there are these state court judges who are terrified of the sheriff, how Latino immigrants felt when he began targeting them. So, the litigation that we brought was we amended a complaint that was filed on behalf of an individual, our first named plaintiff, Mr. Ortega Melendres. It was because members of the community, leaders in the community, like Sal Reza, like Lydia Guzman, and so many other people, came to the ACLU of Arizona and came to MALDEF and said, we need help. We need lawyers to go and challenge what Arpaio is doing with his traffic stops, targeting Latinos for traffic stops, questioning people about their immigration status and then detaining people based solely on his finding that they're undocumented immigrants. Has been a long road. It's still the case is still ongoing, even though we have a new sheriff, Sheriff Penzone. That agency is still engaged in biased policing, and it takes a lot to turn around a ship like the Maricopa County Sheriff's Office. But we won we won a preliminary injunction. We won the trial in 2013. We had to start civil contempt proceedings, and went to trial again in 2015, got 2 extremely long and detailed injunctions to reform, to stop the unconstitutional policing and to reform that agency, which was really infected with bias. And, working with a team that included a private law firm, Covington and Burling, extraordinary work done by Covington and MALDEF and the ACLU, and then the US Justice Department coming in under the Obama administration. But as much as the focus of the press and people around the country was on litigation and lawyering, it was thanks to the efforts of people in the community that anything changed. And of course, we then saw community leaders using the litigation as a crystallization point to then go and do the organizing work that was needed to first oust Joe Arpaio after 5 terms in office, and then leading to his criminal contempt charge and conviction, and then really to a complete political shift in not just Maricopa County and Metro Phoenix area, but around the state, that became such a focal point during the last presidential election. So it's a long story. We could talk a lot more about it, but I just want to really focus on the fact that the litigation, though it absorbed, all of my time and all the legal team's time for so many years, was just a tiny piece of this larger strategy that was community-led.
Well, speaking of the larger community-led strategy, I wanted to just interject with a question from the audience, from Cecilia Valenzuela, asking about what your view is on the effectiveness or the ability to sort of organize to provide immigrant representation in immigration proceedings. Does it stand a chance, she writes. We have one such initiative here in Tucson, Arizona, spearheaded by attorney Margot Cohen and her Keep Tucson Together group. So what are your views on that? And we know there's other efforts or local efforts around the country that are similar.
Yeah, I could turn that question back on you, Ingrid, since as Ahilan mentioned, you've done a lot of scholarship and work on this too, and Ahilan certainly has. I think that getting a right to appointed counsel is going to be key. There's just with the level of unrepresented people who have everything at stake. Who would have a public defender assigned to them if they were charged with a crime, but are facing, potentially much more dire circumstances in a deportation or removal proceeding. It's really critical to get appointed counsel. It's been, many people have worked very hard on this for a long time, including Ahilan. We've tried to litigate a right to appointed counsel and to try to get the kind of success we saw with Gideon, the case that established the right to appointed counsel in criminal cases in the immigration context, and had an initial success in a case that Ahilan led, winning that right for people who have mental disabilities and are therefore not able to represent themselves. But let's face it, it's not just people who have mental disabilities or children or other people who have legal barriers to representing themselves that are recognized by the law. It's, when you've got everything at stake, you're up against, trained government prosecutors essentially, and you're a newcomer, you may not speak the language, and we're dealing with one of the most complex areas of U.S. law. It's a travesty. And we've seen the ways that communities around the country are starting to recognize this, right? With success in New York City, in California. I think that, there's been a lot of success on the part of local organizing, where people in states that are more welcoming of immigrants and who are more interested in civil liberties, civil rights, local officials are taking that responsibility to fund appointed counsel. That is wonderful news. It's progress, but that needs to happen at the federal level. And I think, it's going to be a major issue for us as a movement to be putting pressure on Congress and on the Biden administration to fund that and to recognize how essential it is. Part of that progress too is showing, as I think you've done in your scholarship, Ingrid, that there are efficiency benefits, right, and effectiveness benefits for the system. It's not just a benefit to the individual who will be able to obtain the relief they need or the ability to stay in the United States where they deserve to, but also the system as a whole benefits when both sides are represented.
Great. Your Maricopa County case was such an important win. Another really important one is the Fourth Circuit case that you argued challenging the President Trump's Muslim ban. But as we know, when the Supreme Court heard the challenge to the third version of President Trump's Muslim ban in a 5-4 ruling, it ultimately upheld the ban. Given these kinds of challenges, particularly in the Supreme Court and with some of the conservative appointments of judges around the country, even when we have the best possible legal advocacy that we could have making the claims, what's your sort of, are you optimistic about the potential of litigation in the integrated advocacy frame moving forward?
Yeah, my view about the role or the efficacy of litigation in the movement hasn't really changed that much as a result of President Trump's appointments to the bench, because, the truth is the Supreme Court has not been a hospitable forum for litigating the kinds of immigrants' rights cases that we've had. We had a major win in 2001. When our colleague and our former boss, Lucas Gutentag, won a case in the Supreme Court that had to do with whether federal courts have the power to review these deportation orders that the executive branch issues, as well as prosecutes. And, since then, the focus that many of us have had, especially at the ACLU, and this is an area where Ahilan Arulanantham and Judy Rabinovitz and Michael Tan and many others at the ACLU have really focused on, the Supreme Court has ruled against us a couple times now, right? Initially with the Damore v. Kim case in 2003, which is the first time that the U.S. Supreme Court has approved civil detention, that is detention that's not serving a criminal sentence, without any individualized hearing, right? And much of the last, almost 20 years now since the Damore decision has been trying to litigate every theory we can to restore that fundamental due process principle that the government shouldn't be able to lock someone up without demonstrating the need to lock them up before a judge. Nothing could be more basic to our constitutional values and our constitutional law than that due process principle. And yet the Supreme Court has now rejected our arguments on mandatory detention without a hearing 3 times. In Damore, in a case that Ahilan argued called Jennings versus Rodriguez, and then in a case that I argued called Nielsen versus Preap. And so the Supreme Court, it arguably has, you don't want to prejudge any particular case, but yeah, it's true. It's gone from, 5-4 to 6-3 at this point, conservative majority. But that means that we've long had to deal with a court that was not particularly favorable to immigrants, and in my view, issued decisions on due process and on interpreting the mandatory detention statute that I disagree with. I think they were, wrongly decided. So, all that is a long way of saying litigation's always been a limited tool, right? You've got to litigate, as we saw with the Trump administration. If you don't have lawyers ready to run into court and get injunctions, which we did against really every Trump policy, including the Muslim ban, until it got to the Supreme Court, virtually every case I can think of that we at the ACLU or other partner organizations litigated against the US government during the Trump administration resulted in an injunction. And so the way I think about the litigation is we're firefighters. When you've got this wildfire raging, you've got to go and put out the fire and stop the harm, literally the harm that is being inflicted on people as it's happening. As a result of, the detention cases, until we got to the Supreme Court, we got thousands of people a bail hearing. And as a result of a judge finding that the government didn't have a good reason, a good justification for detaining the people, they got out. That made it possible for them to really litigate their deportation cases. And many of them won their deportation cases. Same thing with Muslim ban. Up until the Supreme Court stayed the injunction that we won, countless people who had the most important events in their life where they needed to come to the United States, get to the deathbed of a loved one, attend a wedding, a graduation, come for a job that they had, fought to get for so long, and so many different reasons people were blocked. Even though at the end of the day, the Supreme Court upheld that Trump policy, the litigation mattered. It mattered that we stood up for people, and we still need to do that, even as, we all as a movement need to work on that longer term work of rooting out those loaded doctrinal weapons that President Trump went and picked up and started using.
I think that's such an important reminder. I mean, I can just say that, our students have even seen in the clinic that I teach, where clients we represent, have not been held detained mandatorily because of the Preap decision, right? Or entitled to a bail hearing because of Rodriguez, that, as you say, like so many people were able to fully litigate their cases and not be held in detention and separated from their families because of those early victories. But of course, even the Preap case that you argued so beautifully in front of the Supreme Court ultimately wasn't successful. There you used a highly textualist argument. And this comes to a question I wanted to ask you, because a lot of litigators have been emphasizing sort of historical or textualist arguments as a way to appeal to certain justices or, more conservative judges. Are you optimistic about using these sorts of tools to litigate in the current moment where we're facing more conservative courts?
I think you use the arguments you have, right? And I think, both in the Jennings case that Ahilan argued and in the Preap case that I argued, I still to this day, look, obviously the Supreme Court calls the shots. Their decision is controlling, but I think we had the right reading of the statute. In both of those cases, the issue was, what exactly did Congress mean with the words that it used? And did Congress mean that mandatory detention could be used for prolonged detention in the case of Rodriguez? And in the case of Preap, the question was, if Congress said the words that the federal government can detain people without a hearing when they complete their criminal sentences, does when mean when they're released from their criminal sentence, or does it mean any time after that? And, I kept, in drinking the Kool-Aid as I was preparing for argument and just how I read the statute. I remember I kept saying, when means when, not if or after. And, was kind of trying to simplify that argument. And obviously it didn't fly with the court. But, I think you use the tools you have. We're now, litigating the issue of whether prolonged detention, the follow-up to the Jennings versus Rodriguez cases, when you have prolonged detention without a hearing, does that violate the due process clause? Going back to the Damore case in 2003 that I mentioned, Justice Scalia wrote the majority opinion, and he focused very much on the fact that the detention under that mandatory detention statute is brief, right? Turns out the government gave the court bogus data. And in fact, the average length of detention under the statute was much longer than the government represented to the court. But that makes sense, from a statutory construction standpoint, that Congress is presumed not to want to enact unconstitutional laws. And so once mandatory detention is okay, if it's brief, there are constitutional limits on that statute. So, the press made a lot about of our Preap brief in particular, and they said there was Mark Joseph Stern wrote, I think, this whole article about like the Gorsuch brief is the new Kennedy brief, and once you're at the Supreme Court, obviously there are lots of people, entire communities of advocates are trying to participate in that process, right? Even outside of the briefing, outside of the parties, and people try to influence the justices in all kinds of ways with op-eds and all that. Does that work? I don't know, but there was a lot of talk about how there's this new Gorsuch brief because he's known to be a textualist. People said, hey, the ACLU just filed this very Gorsuchy brief. It's clearly aimed at him because they're focused so much on the plain language of the statute. And, look, we didn't write the brief that way to try to get Gorsuch's vote. We wrote the brief that way because that's how we read the statute, which is what I told the reporter. But he still has this theory that, the Kennedy brief used to be the brief that appeals to human dignity and these kind of lofty values that Kennedy always talked about in his opinions. And now people say that, we're trying to make more textualist arguments. We make the arguments we have. That's how I see it.
So I think another important dynamic in the Supreme Court in particular has been, that not all cases that affect immigrant rights or that are sort of core immigrant rights cases are being litigated by movement lawyers. We're increasingly seeing, lawyers at big firms, hungry for cert grants, sort of seeing immigration as an area that's hot right now and that's more likely to be heard and jumping onto cases. How does this dynamic impact the development of the law?
It's kind of harrowing for those of us who are movement lawyers. But, I think it's something that we're kind of watching, and we'll see how things develop. I think as we saw the advent of Supreme Court clinics in law schools, where, in addition to the development of a Supreme Court bar, a private Supreme Court bar, where you have lawyers who really seem to be driven by wanting to get a case in the court and that opportunity to litigate and argue a case in the Supreme Court, rather than be motivated by actually having law reform goals that are aligned with the movement, the communities that are affected. The fear has been that cases that we, in the movement normally would try to keep out of the court, to let percolate, to really develop through more litigation in the lower courts before teeing it up in the Supreme Court, the fear has been that those cases that we would kind of try to hold back and continue litigating and developing a record on in the lower courts are going to get to the Supreme Court prematurely and with adverse, consequences for the outcome. And, I think as this phenomenon has kind of developed, I think, I think we see, that a lot of those cases are being won. And this is not unique to the immigrants' rights movement. LGBT rights movement famously, right, was grappling with this as marriage equality became a hot issue. Members of that Supreme Court private bar kind of jumped on it. And in particular, one thread in this dynamic is that, Supreme Court bar, Supreme Court lawyers, Supreme Court specialists who are seen as conservatives, like Ted Olson arguing the DACA case, right? There's kind of a sense that it's better to grab a conservative because those advocates have a better chance of winning over conservative justices, and that's real. You can't really argue against it. The DACA case, that was a huge win, and it was not just, that Ted Olson argued it, but also that, there were amicus briefs filed on behalf of all these major US-based corporations. The Conference of Catholic Bishops wrote, there was a really carefully assembled range of amicus briefs in the DACA case that showed that this was not a partisan issue. It was not a conservative versus liberal issue. This is really a wide range of interests in the United States on the side of DACA recipients. And so there was a win. You can't really argue with that. On the other hand, I would say that, I've written that, I think that the way that those cases are litigated does matter. The fact that, DACA was a huge victory in saving DACA, at least to see another battle another day. But on the other hand, it was a limited victory based on the Administrative Procedures Act. And I was also, I continue to be troubled by litigation strategies that feed into a criminalization narrative, that talk about deserving versus not. People being deserving or not deserving of due process is a big problem to me, and one that I think we need to be really careful not to feed into in the ways that we frame our arguments to the courts. And I thought the DACA case was an example of continuing in that vein in a way that I think could be harmful down the road.
So I wanted to interject with a question from the chat here from Charles Tatum asking about a different court, the immigration courts. Would you comment on your view about the future of the immigration judge system under the Biden administration? In the Tucson sector, the positive outcome of asylum applications is running about 5 to 7%, even when asylees have legal representation.
Yeah, it's a great question, Charles. And I think that both the disparities between different immigration courts, based on city, in asylum grant rates, the disparity between different judges in the same city, and in the Trump administration, the drastic change in outcomes based on the change in administration shows that we have a very serious problem with the immigration courts and with the Board of Immigration Appeals collectively, EOR, the Executive Office for Immigration Review. And it's one, I think that government institutions, it's to the extent that I think the legitimacy of the immigration enforcement, the removal system, is going to be called into question by people. When you see those drastic disparities that can't be accounted for, except to say that the system is arbitrary. and permits those kinds of arbitrary outcomes. If you look at, and it's not just about asylum grants, but also bond decisions, right? Before the end of, before say 2016, we brought up, ACLU brought a lawsuit about this. In certain immigration courts, the rate of releasing people seeking asylum on parole or bond-like release procedure was over 90%. And then Trump takes office, and then the rate of release while people were fighting their cases for asylum goes down to almost zero. That's arbitrary. That there can be no other explanation for that. It's not based on people's flight risk or recidivism. And, so we've got a problem with immigration courts reaching arbitrary outcomes that are obviously of great consequence, potentially life or death consequences for individual people who are, facing deportation charges. But we also have a legitimacy problem. And so I'm hopeful that we'll see some serious reforms. And I think it's been interesting to see how the Immigration Judges Union has become very vocal about some of the reforms that are needed.
Thank you. So this really brings us to the border, which has been an area of, a hotspot for immigration policy for, over a century, of course, and increasingly under the Trump administration. And but throughout different, Democrat, Republican administrations, we've always seen this argument, this refrain coming up that we sort of have to control the border, even if we're inclined to, engage in some kind of comprehensive immigration reform. And we've started to see these arguments crop up again. I think I'd like to get your view on whether, how you're seeing those arguments come out. But how should the immigrant rights movement be responding in terms of narrative strategy?
This is where the rubber meets the road right now. I think it remains to be seen what direction the Biden administration is going to take. I think we're kind of poised right on the cusp of, this is the critical moment, and I'll be really curious to see what Secretary Mayorkas has to say to us tomorrow on this. I think the immigrants' rights movement, just was so relieved, so jubilant when President Biden was elected. And as he was taking, really positive actions, saying things that made so much sense to us in terms of the policies that he intends to carry out. And now we've seen the signs of some backsliding. And I think that we have a lot of deep concern about what direction the current administration is going to take on border-related policies. And we still are very hopeful that the Biden administration is going to do the right thing. To kind of give the a tiny bit of historical perspective, in 2014, during Obama's second term, when there was, again, kind of news reporting about a surge at the border of people seeking asylum, something had been happening, but suddenly it was in the news, right? We, the ACLU and NILC and the American Immigration Council, had to go to court to sue over the Obama administration's detention and kind of roughshod, kangaroo court, to put it bluntly, kinds of proceedings that were going on at this kind of slapdash detention center that was created for moms and kids for family detention at Artesia, New Mexico. And, it was so demoralizing for immigrant communities and for advocates to see the Obama administration saying, literally, this is, almost a direct quote, to these people who are coming from Central America to seek asylum in the United States, do not come, because we are going to detain you. You're not eligible for asylum, and you're going to be deported, and you'll be detained until we deport you. And, as a constitutional lawyer, to hear the president, the vice president, the secretary of Homeland Security say that explicitly for deterrence purposes, to say, we are going to categorically prejudge all of these asylum claims and say, you're not eligible, don't come, because they wanted to stop this political crisis, right? A partisan political crisis that was playing out with reports and spin about a surge. It was so demoralizing, and we had to fight to restore any basic due process in the system, that there wasn't going to be prejudging of both detention and the merits of people's asylum claims. And so, we go through the Trump administration, where again and again he just issued these policies that were just body blows to the U.S. asylum system, and dismantled our system for processing, screening, and judging asylum claims. We thought going into the Biden administration, this is the chance to really, for the Biden administration to break free of this fear-based, irrational, border framework. And, I think the initial moves have been positive. We had 2 cases at the Supreme Court that were set to be argued February 25th and 26th. One on Trump's misuse of military funds for border wall construction beyond what Congress had appropriated, and the so-called migrant protection protocols, or the forced return to Mexico policy for asylum, people seeking asylum. And the Biden administration said, let's take those off. Let's ask the court to take those off calendar. We're going to do a review and decide what to do. They put a pause. They suspended MPP and are now processing in people who were kept in Mexico because of the MPP policy. And on border wall, they've paused construction. But again, you see backsliding as Republican members of Congress have called out the Biden administration. We've seen signs of kind of wavering or backsliding by the Biden administration. I'm still really optimistic that they will terminate those Trump policies, and that they will do the work to actually repair the damage done. Help people to make them whole who were subjected to MPP, to repair the enormous damage that was done to our public lands by Trump's border wall construction in environmentally sensitive and just priceless national treasure kinds of public lands. So we'll see, but I think that's the big danger right now. Is the Biden administration going to do the right thing and actually terminate Trump policies and repair the damage that Trump did? Or are they going to remain sensitive to these partisan political wins when it comes to how the border is spun in the media? And so, to get to your question finally, we're paying a lot of attention to trying to get a true picture, an accurate picture of life at the border out to more people, throughout the United States. I'm not from the border area. I'm from the San Francisco area. I think those of us who live in the interior, I can see how easy it is to fall into the spin about the border being this, area where there's really a national security frame. There's obviously crime, prevention. There's law enforcement that needs to happen at the border. On the other hand, the national security frame has really been abused by people who have a very extreme Trump Trumpian kind of view of immigration and asylum.
So that kind of connects to another question we're getting in the chat from an anonymous participant asking for your take on the Biden administration on why they're continuing to employ some of Trump's regressive policies, despite the fact that there's widespread polling that supports welcoming immigration and asylum policies. And I guess worrying that, perhaps it's because the right will peg him as an open borders figure regardless of the facts. Is that sort of part of the concern going on here, or is it something else?
I do think that's part of it. I think that, with the Obama administration, with many Democratic members of Congress, we've seen them, very sensitive to the partisan nature of the immigration debate. And there are genuine operational issues and law enforcement issues at any border. Of course, that's part of the job of the executive branch and the Department of Homeland Security, is to address those law enforcement imperatives from Congress. On the other hand, I do think that there's been so far signs that there's a missed opportunity here for the Biden administration to take control of the narrative, to take control of the spin as opposed to the operational reality, and to really, there's been so far some troubling signs that the Biden administration has kind of capitulated to the spin that the number of people seeking asylum at the border is a sign of their success or weakness on border security and enforcement. That is a huge mistake, both politically, and it doesn't match up with reality. Because if people are, entitled to asylum under U.S. law, how are you going to say as a metric that the fact that they're showing up at the border to seek asylum is a sign of failure of U.S. border policy? What the Biden administration, in my view, should be doing is to seize control of the narrative and to say the reality is that due to conditions in these three countries, a large number of people have valid asylum claims. And the Trump administration destroyed our asylum system, the system we have for processing people, for screening them, for determining whether an individual is entitled to asylum or not under US law. That system was broken. It was crushed by Donald Trump. And the measure of our success as the Biden administration is how fast can we restore that system to be functional, to be efficient, to be effective, to both screen out threats to the United States, but also to process in people who deserve to have asylum under our system. And if they were to say, that's the measure of our success, right? That having people come to the United States, win asylum, these are future Americans, their kids are future Americans, these are people who are going to contribute to the United States and who have a legal right to come to the United States and seek asylum and then get on the path to seeking lawful permanent resident status and US citizenship down the line. That's the measure of our success. How fast and how well can we restore that system that Trump broke? That should be the test, and not, do we have a surge? Do we have too many people at the border who are trying to apply for asylum?
Great, you're getting some approval in the chat. Bert Voorhees has posted, Democrats will get criticized as having an open border policy no matter what position the administration takes. So why not take principled positions? So we're seeing some agreement here.
Amen.
I also know we're getting towards the end of our time, and we've started to sort of touch on, after talking about all of the, work you've done in past years, we're started to get to the theme of the conference, which is immigration policy under the Biden administration. So for my last question, I really wanted to just ask you to reflect both on sort of what you think the bright spots of the first 100 days are. What has the Biden administration done concretely that you think shows promise and strength? And then second, what are some of your worries about how immigration policy could develop in the course of the next few years?
Sure. I think, we've talked about some of the bright spots already that, Biden came in and very, very quickly, virtually on day one, announced that he was going to at least suspend Trump's border and asylum related policies. We've seen, what I think are good appointments in key positions in the administration and the executive branch. And, I think the key, as I said, they're starting to let in people who had been blocked out by Trump's migrant protection protocols. And so, there are operational issues that, we have to recognize that the government has. They do have to repair and restore things that the Trump administration broke. And that will take some time. But, I think we're still hopeful that on things like the border wall, like the migrant protection protocols, like the Title 42 or public health related entry bans, that they will, quickly actually terminate those Trump policies and make that temporary pause a permanent one. I think the things that I worry about, I wouldn't call it a worry, the things I'm really hoping for that are going to be much more consequential and broader are, how can the Biden administration and how can Congress get rid of those excesses of executive power that made Trump policies possible in the first place. One, huge doctrinal issue is the whole notion of plenary executive power, which goes back to the 1950s and before that. The idea that the statute that Trump used to institute the Muslim ban and other entry bans, including the asylum ban, Section 212F of the Immigration and Nationality Act. Basically, Congress gave the president power to suspend and block the entry of non-citizens into the United States based on national interest. So we saw the House just pass the No Ban Act, which would partially fix that problem. It goes some way toward amending Section 212F in a way that would prevent abuses like we saw with President Trump. But there are so many of those statutory and doctrinal tools for executive excess and executive abuse that I think we need to uproot. And I think we've got to look toward the legislative agenda as well as what the Biden administration does. What we essentially saw from kind of a legal perspective during the Trump administration is a failure of the notion that we can rely on norms of executive conduct, right? Underlying the plenary power doctrine is the notion that the president will do the right thing to protect our country and to carry out the laws in a way that's faithful to the Constitution and to the laws passed by Congress. We've relied for so long in this country on norms of executive conduct that we trust the president to use this, enormous power in Section 212F, or we trust the president to exercise plenary power in a way that protects us. And the courts will generally give the president a pass. He doesn't need to show his work, right? Which is what we saw with the Supreme Court's decision on Muslim ban. Even when he showed us his work on Twitter, the Supreme Court said, we're not going to look at that. We're gonna take what his lawyers have said in court to defend his actions as the record. That's troubling, and I think those of us who've done this work for so long have said, this is dangerous. Having unreviewable executive power is dangerous. Having standardless executive power is dangerous. and being told that you can rely, you could trust the government, you can trust the president to exercise that power wisely and within the confines of the law and the Constitution. The one lesson of the Trump administration is that doesn't work. We really need to see limits, review, codified, and put into the doctrine.
We've gotten so many great questions in the chat, and I apologize for not being able to get to all of them, but we just have one follow-up that fits so nicely. If I can squeeze this in too, what are emerging issues that could shape immigrant rights, but may not be in the mainstream or lesser discussed? I just thought that that would be really nice to get your views on it too, since you've kind of given us the broad strokes, but what are some other issues that are lesser discussed?
Yeah, I think the one thing I'd like to mention there is there are these two criminal statutes they're actually in Title 8 of the U.S. Code, which is the Immigration and Nationality Code, but they're criminal statutes, 8 U.S.C. 1325 and 8 U.S.C. 1326, illegal entry into the United States and illegal reentry after deportation. And I think a lot of people don't know about these statutes, and those who do often, kind of say, okay, those are criminal statutes. That's in a different realm from the immigration enforcement system. And again, it's kind of falling into this idea of deserving immigrants, innocent immigrants, and undeserving or criminal immigrants. There has been so much, and there still is so much attention paid to Trump's family separation policy. And the truly horrific images that we saw and the sounds we heard of children screaming and crying for their parents, and the images of kids being literally torn out of their parents' arms, and then they're being reunited, just things that were just chilling. And I think more people have cared about family separation than it's been the entry point for a lot of people to care about immigration. And I think one thing that has been not so prominent in the coverage of family separation is that family separation was built on a foundation of criminal enforcement. Trump said, I'm going to institute a zero tolerance policy. We're going to prosecute criminally all these people who are coming to the United States and seeking asylum. And so he basically tagged all of these parents as criminals simply by charging them under 8 U.S.C. 1325 with illegal entry. Now they're criminals. And then he uses that as the basis to separate them from their kids. And those statutes are the most prosecuted federal crimes in the United States. If you look at the data on, you might think, a lot of lay people don't even know that things like murder or robbery, those are state crimes, right? So when you're talking about federal crimes, it's already a limited category of things. It's largely drugs. Large quantities of drugs, drug distribution, drug trafficking, armed robbery, frauds. Those are all federal crimes that the U.S. Justice Department and our local U.S. attorney's offices can prosecute. But the most prosecuted federal crime is illegally entering the United States. We are spending enormous U.S. taxpayer resources on enforcing the crime of entering the United States without authorization. And that criminal statute has been used very deliberately by the Trump administration, by people like Joe Arpaio and other state and local officials to call people who are undocumented immigrants criminals. It's a key component of the far right strategies to criminalize immigrants and to make your average American think of a criminal when they think of an undocumented immigrant. So that's something I think that we need to really pay closer attention to. Both the Biden administration can pay attention to it by revising their prosecutorial discretion on when to charge people under those two statutes. And ultimately, I think there needs to be a hard look at that legislation, at those laws by Congress, because they've been such a keystone for the extreme anti-immigrant strategies that we've seen carried out in the last 20 years.
Great, thank you so much. I'm glad we got to ask you that last question. And with that, I think we're out of time. Thank you so much for joining us.
It's been a pleasure. Thank you.
Yeah, I want to thank you both. That was an amazing discussion. It's such a privilege to get a deep dive into your thinking on all these things, Cecillia. I will never forget the story you just told about earlier about talking to state court judges in Arizona and the things that they were willing to tell you privately. That was truly remarkable. Arizona ground zero in so many ways. I'm so thankful for your insights on that. Just two other quick things I want to say by way of transition. One is, if anyone in the audience, if you want to know more about the very last thing Cecillia was talking about, these two criminal statutes, 1325 and 1326, check out Prosecuting Immigration, which is Ingrid Eagly's article now from just about a decade ago that does a really good job of providing a historical account and statistical account also of the phenomena that Cecillia is talking about, which of course has only become more important in the era of family separation and what happened after that. I could say so many things, jumping off points from this amazing conversation, but I'll just say thank you both very, very much again. And for everyone, for the next session, we'll be back at 2 o'clock Pacific time to be talking about immigration detention. Again, the Zoom will remain live, it's the same one. And I think Cecilia's comments about the history of detention litigation should help frame that discussion as well. So thank you both very, very much. And we'll see you all back here in just a little bit under an hour.